state your name, sir.
Mr. Fox, before the court trial, possession of paraphernalia and a no valid driver's license. You understand the charges?
You understand what you're charged with?
No?
No.
No. She doesn't understand. Allegedly, you had methamphetamine on or about your person, and allegedly, it may have been contained within something that qualifies, aka a clear plastic bag, that qualifies as paraphernalia in the state of Florida. And allegedly, you were operating a motor vehicle without allegedly having a driver's license. You understand that?
I understand the driver's license, yes, sir.
Okay, well,
Possession.
I didn't say it was yours. Did I say it was yours? I said you've been charged with.
Right.
Nobody's asking if you did it. I'm just asking if you understand what the charge is.
No.
Yes or no?
No, sir.
Okay, then we'll bring you back tomorrow when you understand.
I was hoping I'm not from this state. This county. If I can just resolve everything today.
You got a parole hold. You wouldn't get out anyway.
You got nowhere to go, man. So, do you understand the charges against you or not?
I understand they charging me with it, yes, sir.
That's all you got. See how easy that is? I don't know why do we have to go back and forth
It's
about
not
it?
easy when you're in my shoes, sir.
It's easy it's a yes or no question. Do you understand?
I don't agree to the
Nobody's
contract.
asking you to admit to anything. I just need to make sure you understand the charge.
I'm a proud citizen, sir.
I'm shocked.
Under UCC focus.
Oh, UCC? Oh, I love it. A sovereign. Golly Moses, I love those.
Buckle up, guys. Today's courtroom chaos kicks off in Florida as Mr. Fox faces charges he insists he doesn't understand. The judge tries to keep it simple, but Fox stalls, dances around the questions, and drops a UCC reference, signaling classic sovereign tactics. The judge's patience thins fast, and you can feel the tension building for what's about to unfold next.
Crap in one hand, hope in the other, and see if that helps. Bond set at 5,000 on the meth, 1,000 paraphernalia, 500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with two N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
It's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right. Good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with the case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please
Here I
tell
am.
me? Well,
I'm here physically present, right?
Mr. Calzada, could you please? What is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent to that.
All right, guys. The judge isn't playing games anymore. He lays out the charges, sets bail, and casually dismantles Fox's sovereign delusions with a mix of dry humor and firm authority. It's a short exchange, but the look on Fox's face says it all. His script isn't working here. The courtroom's mood shifts from confusion to controlled dominance as the judge takes full control.
I was gonna go there today, and you guys were all doing Snohomish County prisoners. Pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
Well, right now you are not responding to my questions. So
Well, you're not responding to any of my I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not perfect.
I come in person so that we can be sure that you understand what's
All right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
Here we go. A new defendant, Mr. Cotta, joined from Bothell, already resisting by refusing to give his name. His "I could change at will" nonsense gets nowhere as the judge orders an in-person arraignment. Cotta tosses out, "I don't consent." But the court quickly reminds him that consent isn't required. This is the first sign that his rehearsed script is crumbling under the judge's calm, procedural pushback.
Ms. Sobe, you're here on the Martin matter, correct?
Yes, Judge.
Let's go have a conversation outside.
He'll be okay. So everyone
All right, today is the date and time set for a hearing in this matter with regard to a bond violation. This is case 242448SM. People versus Eric Martin. Everybody hear me?
Yes. Good morning, Judge. Donna Sobe on behalf of the people, P87439.
Morning, Your Honor. James Gazicki on behalf of Mr. Martin, Your Honor. I have a motion to make.
All right, go ahead.
Your Honor, I was making a motion to withdraw. I've had contact with Mr. Martin before in other matters, and there's no attorney-client communication in this matter. We're talking about different things, and there's just no way of moving forward that I can adequately represent him, Your Honor. So I'm asking to withdraw.
All right, your motion to withdraw is granted. Mr. Martin, would you like a different court-appointed attorney?
Yeah, I guess so, since he shows his willingness not to want to do his job and help me out, and he's misstating, making false statements here, talking about there's a lack of communication. It certainly ain't on my part. I was pointing out to him relevant defenses. He just didn't want to do his job. That's clear what he made of me. So,
Mr. Martin, I have found Mr. Gazicki to be a very competent individual, a very competent attorney in many, many cases. I've seen many trials, hearings, motions, practicing in front of this court, and I find him to be very competent. If you make one more negative comment about him, I'll hold you in contempt of court. I don't do that. We don't act like this isn't the Jerry Springer show. This isn't going to be a bunch of name calling. You're going to knock it off. Knock it off, Mr. Martin. I'm done with everything and you keep doing all your little negative comments, things that you want to say about people. And you think you're the smartest person in the room and that you have some sort of special Juris Doctorate, I guess, from somewhere. I don't know.
Things get awkward fast. Cotta starts rambling about 1099, C bonds, and voter approval. A clear pivot into sovereign mythology, but the judge cuts through it. Even with his tangents, the court locks in a firm date, forcing him into compliance. By the end, he reluctantly agrees to appear, signaling the quiet defeat that comes when fantasy meets the blunt force of courtroom reality.
But you don't have the first clue when it comes to things, and you talk about that. And so Mr. Gizicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gizicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I want to state also that if it was recorded, that we stated would support my allegations.
Boom, time out. Nope, not hearing it. The question is this. Do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. He did. Well, I won't say for the most part. Maybe for the most part, but there's some things he didn't do neither. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
Bye. Have a great time.
Now we hit Judge Slavin's court, and Eric Martin is already in trouble. His attorney moves to withdraw, citing no productive communication. Martin fires back with insults, but the judge steps in hard, warning him against contempt. This isn't a debate. The judge makes it crystal clear that personal attacks won't fly, and Martin's smirk fades as the power dynamic shifts sharply against him.
Okay, good afternoon. My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it, so it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All right.
I'm not sure why you're asking that, but that's okay. All right. So if you would both raise your right hands. Very good. All right. Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department. When I observed the vehicle that Mr. Roosevelt was driving, I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or something?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you don't have to have insurance. Something regarding the Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating commerce, to which I informed the officer that I am not operating commerce as stated in USC 18 USCA 31, paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating.
Judge Slavin zeroes in. He strips away Martin's tangents and demands a straight answer. Get a new lawyer, represent yourself, or hire one. Every time Martin tries to add conditions, the judge shuts it down with precision. By the end, the court has appointed a new attorney, and Martin's control of the conversation is gone, replaced with the quiet reality of the judge's authority.
I'm not using...
For the purposes of that particular chapter of the United States Code, it would not control what happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
It's a motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I am not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay, but, well, I see what
I've heard your argument.
So there will be no further arguments, because I see that you're not going to agree to, because like I said, when I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
Magistrate Heiss takes the bench in Michigan, facing Mr. Williams and his "I'm traveling, not driving" defense. Calmly, the magistrate explains the charges, the fines, and the options. Williams tries to pivot into U.S. Supreme Court references, but the judge doesn't take the bait. It's a textbook example of how to deflate a sovereign citizen without raising your voice, by sticking to facts and the law.
Well, I can tell you this. The Michigan motor vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So
okay, so I
that
stopped
is
you at,
that is what the law says, and that's what I'm finding. Is there anything
okay,
else you
so
want me to consider about that finding?
Shuttleworth v. Birmingham, US 147. Do you mind telling me what the US Supreme Court ruled in that?
US 147 doesn't give me the site of a case. That's an incomplete site of a case. Okay.
It was Shuttle.
And if you wish me to consider the case, why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, US 147, 1969, where it says no license.
US 147 is not a complete cite. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called the Federal Reporter, 2nd edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the parties to that case and what issue was before the Supreme Court in that case?
Okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't tell me what, that's not a complete cite of the case.
All right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
there are documents that have been scanned into the court that you dropped off.
Okay. So
from those documents, why don't you tell me the proper citation for Shuttle versus Birmingham?
Okay. Traffic infractions are not crimes, blah, blah, blah. Person faced with, okay.
Right. Traffic infractions are not crimes. That's absolutely correct. They are civil infractions for a reason.
I was reading from a different case, but the case that I'm citing from states that no license necessary to drive an automobile on public highways, streets. No license is necessary. The word operator should not include any person who solely transport his own property and who transport no persons or property for hire.
Where's that citation from?
Okay, I just appeal it, and that way I can make sure all citations are.
That's fine. I mean, the idea is I can't look up what you're telling me, right? Without a proper citation. So you can read, I mean, for all I know, and I don't mean this, I'm using a farcical example. For all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no jurisdiction over Michigan.
It's understandable.
I don't know.
So I would cite Payne v. Massey, 19196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else you want to present to me?
If you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like you said, I have a right to appeal it. So
yeah, and I'm willing to listen. If you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise people could just run around quoting Mickey Mouse if they wanted.
Right. Okay. So
nothing against you. So the question to you is, what else do you want me to consider at this point that you haven't yet told me?
Okay. Zobel v. Williams, 457 US 55.
And why are you citing that case? What is it telling you?
Because it states that, let me see the above, blah, blah, blah. To travel unencumbered and fettered on common public way or highway, which is their right to so do.
Absolutely.
That the right to travel is constitutional protected.
Yep. Anything else you want me to consider?
No, sir. No, sir. No.
Okay. I have no problem telling you have the right to travel. I have no problem telling you have the constitutional right to travel. All citizens do. No doubt about that.
One question. Is there a difference between a motor vehicle and an automobile? Is there a difference?
Yes. All automobiles are motor vehicles, but not all motor vehicles are automobiles.
Okay, so is my automobile not my private personal automobile that's not being used in commerce?
I would have no idea the use of your motor vehicle, and it's not relevant to me for the purposes of deciding whether you're responsible for these civil infractions.
Okay. Well, I have nothing else for you to consider.
Well, very good. I'm letting you know the law does not make a distinction between your using the vehicle for personal reasons or you're using the vehicle for commercial reasons when your registration plate is expired and when you fail to show proof of insurance. Both of those are required.
The MCL language.
Both of those are required under Michigan law for anyone operating any motor vehicle. That's what I can tell you. So
correct.
If you're
a motor vehicle, to which I am not operating a motor vehicle, and this is what we are trying to circumvent.
All right, guys. The showdown ends with Williams reciting a patchwork of case law and God's laws rhetoric, claiming all regulations are unconstitutional. Magistrate Heist, unshaken, questions the source, points out the flaws, and keeps the hearing on track. It's the ultimate reality check. Courtroom rules, not personal theories, decide outcomes here. Thanks for watching. Don't forget to like the video, subscribe to the channel, and we'll see you in the next video.
Yeah,
I am operating my automobile, not a motor vehicle.
I can tell you that an automobile is considered a motor vehicle under the Michigan Motor Vehicle Code. So that's fine. Is there anything else you want me to consider?
Nope.
Very good. All right. So I've listened very carefully to the evidence. I do find that it's more likely than not that when you were required to by Officer Kellums at a traffic stop show proof that your vehicle was insured, that you failed to do so, and that it is more likely that your not your operator's license, the registration plates on the vehicle were expired. So I'm going to assess the $125 on the no proof of insurance case and the $110 on the expired plates case. All right. Thank you both for your time and patience. You're all set. Have a very good day.
Thank you, sir. You too.